Hi, and welcome back to my channel. I'm Dean Rod Vera, and today we'll talk about the recent Supreme Court decisions on how social media posts are used as evidence in a criminal case. Stay tuned. Around June 17, the Supreme Court released a decision regarding how FB Messenger posts are used as evidence in a criminal case. Apparently, some of the news media outlets gave these as headlines. The first one here, and the second one, as you can see on the screen. They are a bit misleading because the correct headline, as used by the Supreme Court Information or Public Information Office, released this headline or this news item. So as you can see, the Supreme Court labeled it properly. How messages or posts in FB Messenger can be used as evidence. This is the case of Cadahas versus the Philippines. That's the title of the Supreme Court case, but normally people would say People versus Cadahas. The case is titled Cadahas versus People of the Philippines. I'll give a link below on how to access that case. This is a pretty grim criminal case. It involves a pedophile, for lack of a better term, asking a minor to send pictures of her private parts via Facebook Messenger. Here is the facts of the case as stated in the Supreme Court printout or the Supreme Court issuance. There's a minor who was courted by a pedophile. Excuse me if I use these terms, but there's no other way to say it. The pedophile in the relationship with the minor, they're exchanging messages, sweet messages. The case didn't say whether they saw each other or not. The mother of the child, the minor girl, was able to find out about the relationship and sought to ban it or stop it. Apparently that didn't work. They continued their relationship, albeit secretly. Now, what I can gather from the case is that the guy, the pedophile, gave the password to his Facebook account to the minor girl. And according to the facts, and I don't know how it's done, she would send messages on his Facebook account to him. I think it was a way to make sure that it wasn't her Facebook account, but his. But nevertheless, the key factor here is that the pedophile gave the minor girl, the victim, access to his Facebook account by giving the password. The mother eventually found out, and through reading of the messages, she was able to see that the minor girl sent pictures of her private parts to the guy, to the pedophile. Then a criminal case was filed against him for both abuse of a minor and violations of the Cybercrime Act. He was convicted in the regional trial court, which was affirmed in the appeal with the Court of Appeals. And from the Court of Appeals to the Supreme Court, the guy, Cadahas, invoked a new defense, saying that the pictures obtained through his Facebook account or his Facebook Messenger were violation of his privacy rights. The new defense of Cadahas on an appeal to the Supreme Court stated that the use or the admissibility of the photos obtained from his Facebook Messenger account should be inadmissible because they are fruit of the poisonous tree. Could it be? Let's taste the evidence. Let me make a spoiler alert here. The Supreme Court said the defense of Cadahas is with no merit, meaning his conviction stood or was withheld or sustained or affirmed. So, with regards to his violation of his privacy rights, the Supreme Court gave a twofold reasoning. First, the privacy rights under the Constitution can only be invoked against the state or the government because the photos in his Facebook Messenger account were obtained by a private person, the mother and the minor child, the victim. They are private persons. Therefore, he could not invoke his constitutional right in protection of privacy against that. His privacy rights under the Constitution were not violated. What about the act of the data privacy law, where those rights under the DPA violated? The Supreme Court said no, because the law stated that if the information was considered private is used in determination of the criminal liability of the person, then that is an exception to the Privacy Act. In this case, the photos obtained were used to determine the criminal liability of Cadahas. So therefore, it is not a violation of the Data Privacy Act. The second reason why the Supreme Court defended their affirmation of the conviction was that Mr. Cadahas, the pedophile, lost his reasonable expectation of privacy, or what in the legal parlance we call REP, by giving his password to the minor victim. He lost all his privacy rights, so to speak. In his defense, both in the regional trial court and all his pleadings, he did not invoke, I was hacked, my account was hacked. No, he volunteered or he admitted that he gave the password to the minor. On a counterpoint, it was stated in the facts that the mother forcibly asked the minor child to open the Facebook account. That defense did not hold water because he still gave away the password. To correct the misalignment of the headlines, it is not accurate to say that social media points can be used as evidence against anyone. Or rather, the headline was presupposing or alluding to that what happens to your social media post, can they be used as evidence against you? Technically, there's another reason for that, but the Supreme Court stated that it is the messages or the posts in the Facebook Messenger, they can be used as evidence in a trial court. So it's not technically social media posts because, and this is my personal opinion, information or messages in the Facebook Messenger app are technically not social media posts. It's a social media app, but they're not a post because they are correspondence between two people, at least for this case. So technically, it's not a social media post, it's a private post in a social media app, or the messenger function in the social media app. Okay, let me boil this down again. It being in Facebook is really actually irrelevant because whatever mode or medium it was, the communication was given, the mere fact that the accused, the pedophile, gave his password or gave access to that person, and that person had the chance or the ability to use that information in the Facebook Messenger. If you correlate this to actual mail, if I ask somebody to open my mail, sealed, it was a sealed envelope, and I asked that person to open it, I lost my reasonable expectation of privacy, and whoever opens that envelope under my authority, if he sees anything inside, he can do anything with it because I gave him access to the envelope. That's the same thing what happened here. By giving the password to the child or to the minor girl, he gave access to the envelope. Whatever was lost here by the giving away the access was the ability to argue against the admissibility of the evidence or the documents or the photos obtained in the Facebook Messenger. So what lesson can you learn from here? You want it private? Keep it to yourself. Hi, please do me a favor and smash that like button. It'll help me a lot and it will trigger the YouTube algorithm. Now, if you have not yet, please subscribe to my channel. If you don't, my dog will eat this exam booklet and that student has to repeat his final exam again.